Formal law school training is a prerequisite in most cases for the lucrative practice of law, and perhaps in aspiration. There are few persons in college who aspire to become a great trial attorney, presenting arguments as a litigator on important issues of the day. But the simple fact is that of the 1.33 million attorneys in the United States, the most highly compensated attorneys are employed in less than 1% of the firms that are designated as large law firms with over 100 attorneys on staff. Most of those in large cities like New York, Washington, Los Angeles, while 83% of all attorneys are employed in considerably smaller law practices with fewer than 50 attorneys, many in small towns, and some even in large cities. Guy who just decided to put out a shingle. And consequently, in 1995, over 65% of attorneys were actually considering new jobs. And by 2008, over half of attorneys admitted that they were very dissatisfied with their jobs. Bottom line, more likely than not, you will not be that dashing attorney at a big law firm, regardless of whether your mother is saying, "My son, the attorney," working over 80 hours per week and earning more money than you can spend, especially if you have not graduated from a top law school and happen to have very good connections. Because these top firms with high-paying jobs tend to be very selective and will not hire just anyone. And if you happen to land that job at one of the law firms, as they say, your chances are higher that you will become a litigator, since 30 to 40% of their practice is in the field of litigation. But don't get your hopes up too high, because only about 2% of all cases ever make it to trial. Interesting factoid about attorney jobs is that most of the work in litigation, particularly, you'd probably earn more money as a restaurant manager. So, bottom line, if you're thinking about law and being a big litigator, the chances are high that you will not be arguing that landmark case, and more likely than not will be that ambulance chaser stereotype that you loathe to see on television, pitching for a sale, asking you if you've been injured and telling you that if you've got a phone, then you've got a lawyer. But still, many believe that formal law school training is of some value, because you learn, or at least have the opportunity to learn to think like a lawyer, which is never an entirely useless skill to possess. In the last segment, we began with the law student skill of briefing a case by reviewing the facts before the court. And in law school, you will experience an endless stream of fact patterns, whether in class being interrogated by a law professor engaged in a particularly sadistic Socratic method, or on a comprehensive final examination. And your mission, should you choose to accept it in this laborious exercise of critical reading, is to discover within these fact patterns those pertinent facts that help to develop a prima facie case, complete with all of the elements to satisfy some theory of law and contracts, torts, criminal practice, or whatever your chosen specialty. And this labor-intensive, perhaps even tedious exercise, a lot of reading, is directed at refining the issues to present before the court, which is why it is often described in law school as issue spotting. Obviously, the more practice that you obtain in reviewing these fact patterns, the easier it is to identify those pertinent facts to distill an argument to present before a court, brilliant as it may be. And so you might say that in law, practice makes perfect. An attorney joke. And so, in the case of Jacobson v. Massachusetts, the matter at bar, what was the issue before the court? Initially in the trial court, as you recall, for the city of Cambridge, the issue was very, very simple. Henning Jacobson had broken the law beyond a reasonable doubt in their mind, refusing to be vaccinated against smallpox that had become a persistent problem in that community, but not the state. But Henning Jacobson, after reviewing this fact pattern presented to him after receiving a $5 fine, was prompted to consider at least 25 ideas about why he should not have to pay that fine or submit to being administered the vaccine, which in the end, as we know, was to no avail. In part because Henning Jacobson had confused zealous effort doing something with actually developing a course of action that was cleverly calculated to prevent his loss. How many kids missed that on the test? Like the descendant Delta variant of concern, he presented to the court a high viral load of defense arguments. And we all know that a high viral load means that you have to have success in infecting the court, on the hopes that perhaps just one, no matter how ill-conceived, might find success. And perhaps if you are a single strand of ribonucleic acid, you can continue with that plan and conquer the world. But the lesson of Henning Jacobson is that if you are just a person, you'd best not try that approach in court. But at least during the trial, Henning Jacobson had one shining moment after his 25 ill-conceived defense arguments had failed to convince the court that had to inform him that he was not an expert. Henning Jacobson decided to exert his influence over the jury by presenting a jury instruction that he had hoped would help him to prevail on the merits in his criminal case, arguing for him in that jury room even though he was not present. And this caused Justice Harlan to address it at the very beginning of his opinion, indicating that Henning Jacobson had made at least some impression upon the Supreme Court that had deigned to accept his appeal, which is rare in itself. From the syllabus, we find these facts. The prosecution, having introduced no other evidence, the defendant made numerous offers of proof. But the trial court ruled that each and all of the facts offered to be proved by the defendant were immaterial and excluded all proof of them. The defendant, standing upon his offers of proof and introducing no evidence, asked numerous instructions to the jury, among which were the following: that Section 137 of Chapter 75 of the revised laws of Massachusetts was in derogation, very impressive, of the rights secured to the defendant by the preamble to the Constitution of the United States, and tended to subvert and defeat the purposes of the Constitution as declared in its preamble. And this is a good place to pause. To his credit, Henning Jacobson had endured the wait of 2 years just to get to an actual trial. After his conviction, he endured 1 more year presenting his argument to the United States Supreme Court, placing him in history. He knew to come to court with at least some type of arguments, but had no idea that his opinions, although definitely valued by him, were not those of an expert meriting any work before a trial court. And even worse, as a litigator, he had presented absolutely no evidence to support his arguments, hoping the court just might accept him as an expert and listen to that which he deemed to be reason, which, unless you happen to be Albert Einstein, is rarely a good idea in court. It's just not. But he does yet recover here, and has the good sense to present instructions to the jury which indicates some level of courtroom savvy, and he must have sounded at least a bit authoritative to those who heard him by citing to a particular chapter from the Massachusetts Code of Law. And perhaps at this point he was even looking beyond his present trial with an eye toward going to the United States Supreme Court by raising a federal question or attempting to present some conflict between the laws of the state and the federal law, because a federal question is often required for a federal court to exert jurisdiction. A lot of times people don't realize that when they're in a court, how these things work together or apart. But what was wrong with this novel argument presented by Henning Jacobson that immediately caught the attention of Justice Harlan of the United States Supreme Court? Let's review it once more. That Section 137 of Chapter 75 of the revised laws of Massachusetts was in derogation of the rights secured to the defendant by the preamble to the Constitution, and tended to subvert and defeat the purposes of the Constitution as declared in its preamble. Well, Justice Harlan jumps into this argument immediately, beginning of his opinion, setting the tone for the rest of the case. He states, "We pass without extended discussion the suggestion that the particular section of the statute of Massachusetts now in question is in derogation of the rights secured by the preamble of the Constitution of the United States. Although that preamble indicates the general purposes for which the people ordained and established the Constitution, it has never been regarded as the source of any substantive power conferred on the government of the United States or on any of its departments. Such powers embrace only those expressly granted in the body of the Constitution, and such as may be implied from those so granted, although therefore one of the declared objects of the Constitution was to secure the blessings of liberty to all under the sovereign jurisdiction and authority of the United States. No power can be exerted to that end by the United States unless apart from the preamble it be found in some express delegation of power or in some power to be properly implied therefrom. Politics is all about power. So make sure that you understand this so that you don't try this at home. The preamble may be the only thing that you were taught to remember in school, and you may even be able to sing it in three-part harmony. God bless you. However, as a legal argument, even in your thoughts about spirits of law, it has no legal authority and is more like a preface or a foreword that you might find in a New York Times bestseller from a celebrity offering his or her considered thoughts, but not as an expert, so much as just a paid or even unpaid endorsement. Understand that the preamble is a part of the Constitution, but think of those separation of powers. And you might notice that in the preamble, neither the executive, nor the legislature, nor even the courts are delegated a specific power to do any one of those things specifically. It is merely a hope, an aspiration, a dream deeply rooted in the American dream, that when they fulfill those specific obligations delegated in the articles, that they might, on chance, remember. And so Justice Harlan states, for history, we also pass without discussion the suggestion that the above section of the statute is opposed to the spirit of the Constitution. Undoubtedly, as observed by Chief Justice Marshall, speaking for the court in Sturgis v. Crown and Shield, the spirit of an instrument, especially of a constitution, is to be respected, not less than its letter. Yet the spirit is to be collected chiefly from its words. We have no need in this case to go beyond the plain, obvious meaning of the words in those provisions of the Constitution which it is contended must control our decision. So, like General Alston, Secretary of Defense, said, get the shot and stay healthy. Jacobson v. Masterson supports it. It is abundantly clear upon all evidence that a God in heaven simply does not like you, love notwithstanding, and it is not true Or is it not? That 3 generations of imbeciles are really quite enough. Get the shot! Fools rush in where angels fear to tread. This briefing is unclassified, as you were. My name is Major Mike Webb, and by God, I am running for Arlington Public School Board. Let's keep Mike Webb away from our schools. Honest, carry on. This advertisement was authorized by Mike Webb.